All right, everybody, welcome, welcome, welcome. So I thought I'd come in and give my take here on the state's case since it rested. I wasn't expecting them to rest today. I wasn't expecting that to be the final witness. I knew their case in chief would be lean because I knew that the defense was stipulating by fact, by statement of fact, that she did this. So state was putting on really information to, I think, combat what they know is going to be the defense's potential use of the insanity defense, which remember, the defense must make a showing by preponderance of evidence that she did not know right from wrong. So I believe what the state was trying to do here in this case was, of course, prove their case by the facts, showing she admitted it, showing that this child died, showing the circumstances surrounding the death, showing her statements to police, but most importantly, demonstrating some important facts, one of which that came out today in her statement, which was to the police officer, which makes a tremendous difference to everything here. And that was that she arrived at the house, made a conscious decision to go downstairs, get the knife, close the door, lock the door, and then commit the act. Why, you ask? Is that such a big deal? Well, that's because you wouldn't, if she wasn't aware of right or wrong, she wouldn't have shut the door, or at least that's the argument that the state's going to make. On top of that, you have her statements made after she comes out of it to police, right away worrying about her prison sentence. She was worried about a prison sentence to the doctor. She was worried about going to jail, all demonstrating that she knew right from wrong. So that is what the state's focusing on, because that in Georgia law is the only thing that matters. It doesn't matter that she has mental defect. That is not the at issue. It's whether the mental defect caused her to not understand right from wrong, and whether or not at the moment that this happened, was she defected in such a way that she didn't know right from wrong. And the bottom line is, that it's important information like her going down and getting the knife. Those are the things that this case is going to hinge on. Now, of course, the defense is going to bring experts in, I anticipate, starting tomorrow, that are going to take on the fact that says that behavior, even though she's doing those things, it does not mean she knew or that she understood that what she was doing was wrong. That she could be in a state of basically just lack of, she's in a fugue state. She has a belief system that says she has to do what she has to do, and right and wrong, it's not factored into decisions. It's the fact that she's been abused, that she's been put in this state, that she's in this psychosis, that she says, I don't know right from wrong. Yes, she's going down and getting a knife because she's operating at a subconscious level that's just like, hey, I got to get the knife. I got to kill the baby. I got to do this. And the fact that she didn't stop or that she didn't do that, if she knew what right from wrong, she wouldn't have done it. That's what the defense is going to make their argument. On top of that, I believe you're going to see basically, in addition to the psychosis, I think you're going to see them argue part of what was factoring in here. It was postpartum psychosis. That this was part of postpartum depression, and the fact that this was she was running around with these people that don't like medicines and over-the-counter medicines. That Ben Yad and Eliyahu didn't want her taking over-the-counter stuff. So as a result, she doesn't end up getting treatment. She doesn't end up getting help. The cell phone video, which the defense played, is helpful because you can see that she was having her mind games played. Benyamin had taken the baby and basically told her that he was doing things to the baby and that he had access to this higher level of reality. Because remember, one of the important things is she believed he was some sort of a religious cult shaman leader or whatever. So it appears we also got an important question answered here, and that is that Benjamin is not testifying. I don't think the defense is going to call Benjamin, although maybe they will. But it's far different when you're calling Benjamin on direct examination versus getting to cross-examine him. But perhaps they will call him because if he's willing to say that she was absolutely in a moment of psychosis, that she did not appear to be present in Georgia, under Georgia law, they are allowed to present lay witnesses, and they are allowed to present their observations to the jury. And the jury is allowed to attach to it the weight that it wants. So this is going to be interesting because, like I said, there's layers to this case. The defense now will have to prove in their case in chief they will have to meet the burden of proving beyond a preponderance of evidence that she was temporarily insane and unable to see right from wrong. If the judge makes a finding that they've reached by preponderance of evidence, or that in the light most favorable to the defense that it was reached that way, which is essentially presumption of innocence, that's how everything has to be, that a jury could find that based on what was presented, or they could disagree with it, but they could find it, then the defense will then get the instruction that says that if the jury has found that the evidence that was presented establishes by preponderance of evidence, basically by greater than a 51% chance that she didn't understand right from wrong, that they have to find her not guilty. Because at that point, the defense triggers it, and the state must disprove beyond a reasonable doubt that she knew right from wrong. So it kicks in, and the burden now kicks back over to the state. That if the state does nothing past that, and all they've ever established is that she did this, but that the defense has satisfactorily established in the jury's mind through their witnesses, through the cross-examination on the state's case, that she did not know right from wrong, even if they're not 100% convinced, if they have a doubt about that, then they're going to get the instruction that they must find her not guilty. So this is why I said this is like where a second trial is going to happen. They're going to have the defense's case. If they get the instruction and the judge gives it to them, then we're going to have phase 2 of the state's case. And I do believe in cases like this, there might be an attempt, although I don't think so though, because it's very limited times that you ever see a defense get to put on a rebuttal to the rebuttal. But it's possible something came up that could happen, but more likely than not, a lot of times the defense doesn't get the rebuttal because they have the presumption of innocence. But we're going to see the state's case phase 2, and then it goes to the jury. So this is why I believe at this stage of where we're going, depending on the pace, depending on how long this doctor's and how many doctors now. Be aware the defense can't come up here and put 6 doctors on the stand to say the same thing. Okay, the judge will exclude it. So we're going to hear from one doctor who's going to probably talk about maybe the psychosis part, and you might have a doctor or specialist on postpartum depression and how that would have factored in. And then they're going to put their own lay witnesses on, I'm sure, that were around her to say that they saw the things that the doctor said that they would be seeing in this instance. And then we will have that pivotal moment on whether or not the defendant testifies or not, whether or not the defense feels like they need to hear from her or not. I feel like in a case like this, somebody who's mentally disturbed, somebody's under the degree of medication that she is, I would think the defense would say, we're not putting her on the stand. They heard from her. They heard her statements or written statements. What else do you need to hear in this instance? Because it's more what she told the doctors. They're going to be able to have the doctors say certain things they were told and aspects they were told. But I don't believe she's got to testify in this instance. But we'll find out. We're going to find out. And I don't really think that there will probably one or two. That's not going to necessarily help. Although maybe she will. Maybe she'll get up there and say, I don't remember anything. I remember walking into the room or walking into the house. I remember, again, putting Benjamin on trial, putting that other guy on trial. It's going to be what the defense is going to want to do. And they are going to want to generate a large amount of sympathy for her. So the only way they get that stuff in is if she's willing to come in and talk about it. So like I said, the case, this is why it's a 3-week case, because it was expected that the first week we're going to get the first part of the trial. Now we're going to move into the second phase. And then you're going to get into the state's case where they're going to bring their doctors in. They're going to bring their people in to, again, attack and focus on proving that she knew right from wrong. Maybe we're see Benjamin then. Who knows? We'll see. But it's going to be very, very interesting. So it's just getting started. And with tomorrow being a Friday, we definitely won't have, I don't believe they're going to do court on Saturday. So, I don't know how long the defense's case will be. Again, this is where cases can be scheduled for 3 weeks. And we could find out that the defense puts on 3 witnesses tomorrow. It goes super quick. They rest. The state says we don't have our expert ready until Monday. Monday, state puts on an expert or two. And we could suddenly be in, we could seriously be, in Peyton and Friends. Yes, I am. I'll tell you why. I don't know if you know why I'm wearing it. My son is a type 1 diabetic. That's why I wear it. This was given out at a diabetic awareness, day at his school, and I've worn it ever since. He's a type 1 diabetic since 2020. So I wear that in support of him. So that's why I'm wearing that. So yes, I seriously am wearing a blue bracelet. So what is your objection to the blue bracelet? What would your is there something that you're attaching to it besides the diabetes awareness? Because that is the purpose that I'm wearing it for. So, but that's a big deal in our house because, like I said, my 15-year-old is a type 1 diabetic. So, like I said, I wear that in support of him every day, and bring awareness to it. Bring awareness to hopefully bringing costs down related to that, because it's one of the biggest challenges that type 1 diabetics have as they get older, is ensuring that they can have access to the things and resources they need at a reasonable cost to be able to keep them alive and keep them going. So it's a cause that's close to my heart. So absolutely, I wear it with pride. So that whatever you might be atoning it to or attaching it to, Peyton and Friends, that's not what it's about. So, anyways, sorry you have a problem with it. Anyways, so with that said, guys, like I said, that's where we're at on the case. I think it's going to be an interesting day tomorrow. So, I mean, I think at this stage right now, obviously the defense needs to put a case on. I think at this stage, obviously she would be convicted because they've stipulated that she did this. We've seen a good bit of evidence come in that the state could absolutely argue. So there will definitely be a need for a case. But we'll see. We'll see what happens. I think now is when we have to open our minds up and listen to these doctors and listen to the experts and get out of our own way. Let the experts guide us, and we will come hopefully we'll come to our own decision, but we really don't matter. It's what the jurors decide. It's what the jurors decide. So, we will hopefully have an opinion that closely mirrors their verdict, but we'll see. Now, of course, as many of you may know, or maybe some of you don't know, go over and check it out. I'll be, of course, putting it up here eventually. I'm a little bit behind on that trial with highlights and clips, but the McKinley Louisma trial had a verdict today. The only surprise about the verdict was how long it took. I thought it was going to be like a 45-minute to an hour verdict. Took a little longer than I thought. I was very surprised the jury had so much to talk about, because for me it would have been an extremely quick guilty. Perhaps they ate lunch first, took their time going through and just saying, you know what, we're going to give this young man at least the benefit of talking the case through one time and then voting, because I guarantee you that I can't imagine there was a person in that room who thought he wasn't going to be convicted. But you never know. You never know. Maybe somebody had some sort of an issue, but this case could be very different when it gets to the jury. I think it's going to be one that is going to, at the beginning of this, I was thinking, well, there's not much to it, But I think that if this is presented right, if her attorneys do a good job, could be a lot to talk about in that jury room. It could be very interesting deliberations. I don't think it will be as long as the Ferris deliberations, but I don't think it'll also be as long of a trial either. But we'll see. We'll see. And if it does get to a deadlock, I would love to see what this judge does versus Judge Cannon, who gave the Cannon argument or the Cannon instruction, which is apparently something that he does well before he does the customary jury deadlocked instruction, according to the defense attorneys. Apparently, he gives like two of his own instructions before he gives the Allen charge, and then once the Allen, because normally I'm sure some of you know from watching trials for years, once the Allen charge is given, you've got to let the jury go. So he gets around that by advising the jury a couple of times to go back, and then gives the Allen charge as kind of the cherry on top. And then if they still can't come to a verdict, boom. And in Georgia, again, Georgia's a strange state. It's a strange state for parole. It's a strange state for insanity defenses. On jury deadlocks, it's also a strange state too, because they really leave it a lot of discretion up to the judge. They do not require the judge to give the Allen charge at any specific time. And there has been quite a bit of case law on it. I looked it up. But in Georgia, it's when the judge wants to do it. So it's at the judge's discretion, and the Georgia Supreme Court and the U.S. Supreme Court has affirmed the Georgia Supreme Court saying that the judge has that discretion. They've affirmed it. So it'd be very interesting to see if this judge operates in the same vein, or is she quick to call a mistrial? I don't know. We'll see. But with that said, guys, like I said, I just wanted to come on here. I felt like I've got to come on and at least speak a little bit here because the state's case is over. So now we will move on to find out what the defense is going to do here, find out what the defense is going to bring us, find out if we will finally get to see the most talked about man right now in this case, which has been Yamin Eliyahu, the prophet himself, will come on and speak to us and tell us what he saw. I really, it's to me crazy that the state wouldn't have called him, right? Because he was the one there who encountered, who kicked in the door. But perhaps that's because they don't like what he's going to say. And that could be very significant. So we'll see what happens. Anyways, guys, I will see each of you tomorrow. Thank you to all the new members. Thank you to everyone in chat. Thank you to all the new subscribers today. Thank you for all the generous super chats. Very, very much appreciated. Helps keep this thing going. And it was great timing, as today I upgraded my streaming service to make sure we have 10 hours. And then, of course, court ends early. So that was an extra few dollars. So it was a good timing on all of the generosity. So I really appreciate that. Will help offset some of that. And Sam says unpredictable. What's unpredictable? Are you talking about unpredictable as far as what the case will be, or unpredictable? What is unpredictable, Sam? Elaborate a bit before I go off. Or maybe it's something I said. Oh, yes. Okay, I got you. Yeah, absolutely, Sam. You're right on that. So I think he is unpredictable. I think he's also a little bit nuts himself. I mean, well, I don't want to put the guy up at this point, because it is on YouTube. But I just feel like he's not on trial. He's not been brought into the trial. So until that happens, he's not a public figure yet that's been broadcast. So I make a habit. I'm not going to sit there and broadcast. Now, he put himself on YouTube. He put this up, but at the same point, once he gets brought into the trial, maybe we'll go over and look at it. I saw the site. I'm pretty certain that is him. Almost 100% certain. That's the other thing. But let me tell you, I can understand if that is him, and I believe it is. His voice sounded just like the voice we heard in the recording. Dude sounds like he's out there on another planet for certain. and putting that in front of the jury. Not to mention that you could already hear the other guy they put in front of the jury. He was pretty clear in saying that he thought that she was, should be set free. And let me tell you, Benjamin, if he comes in because he's the guy who put eyes on her at the moment, it's the most significant witness in the case, because what he sees, what he saw. Now, understand this too. All right. If he told the police something different, he comes in and tells the defense if they were to call him, then that's going to be a problem. But if he has consistently said that he thought she was, not of sound mind at that moment, and she was in some sort of a psychosis or state that was outside of herself, that could be huge and significant and something for the defense, which I'm sure the state would rather, not put him on and then be able to come in like the defense did and just crush him on cross-examination and cross-examine him to show his bias. But we'll see. So anyways, with that said, guys, I am going to jump off here. I appreciate each and every one of you. Appreciate everyone that's been in the chat today. Appreciate all the mods out there that are helping to keep this thing a great, safe place to come and enjoy trials. And I'll be back tomorrow, and we'll talk again. So until then, guys, let justice prevail, and I'll talk to you soon.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa.